had some state court litigation now, and we're trying to use that fact to try to resolve it with the bank rather than have to go into bankruptcy and deal with it that way. In a Chapter 13 context, I talked to Ed about this a couple of days ago, and it's similar to what you might be able to do in Chapter 13. If you find a problem with a deed of trust in a Chapter 13 case, you don't have to file an AP and go to blows on it. You can use that as an opportunity to try to work out favorable treatment with that creditor. Ed, I know that you've been successful on maybe a dozen. Okay. I also spoke with another attorney who said that in Chapter 13 cases, their firm will get employed by the trustee to do this action. So another way to do it.
Since you mentioned the Chapter 13, can you go back to Al's question earlier about how it impacts the liquidation analysis if you do avoid one of these deeds of trust? Because I think you got interrupted when you were trying to answer that earlier.
Interrupted. Pam's question is...
I am very sorry.
You can't help your programming. The question Pam had out was if we could go back to the Chapter 13 context and how avoiding a deed of trust might affect the liquidation test and that sort of thing. What do you think about that? Or was it your question?
I posed that question, and I would be interested in what some of the experienced practitioners think. Do you think if you know there's a defect, if you're reasonably sure that Chapter 7 trustee would, but what if a trustee in your district, they just don't care about these issues? What if in the, if you're in the Newbern division and you know George Oliver is going to sue that creditor and avoid the deed of trust, it's a slam dunk, and get $100,000 for the unsecured creditors. Is that different when maybe you're in the Wilmington division and you know that you'll get me and I don't care about those issues and it'll never come up?
Stop lying.
These are purely hypotheticals.
Well, isn't it the difference between it being avoidable as opposed to void?
So the question is the difference between being avoidable and void.
So don't you have to take an affirmative action to avoid the lien?
You do.
So I guess the question is whether the debtor's attorney should be tasked with anticipating the likelihood that somebody else is going to take that affirmative action.
But in Chapter 13, it seems that regardless of who takes the action, because many times the action is not taken in the 13, but you still have to provide your creditors if somebody objects, which in the Eastern District, the trustee's motion to confirm is I think, interpreted as a kind of standing objection. You have to provide your creditors at least as much as they get in a Chapter 7.
What about if you're a Chapter 13 debtor's counsel and you don't want your Chapter 13 debtor to be disqualified because of the debt limits if you avoid a mortgage that goes from secured to unsecured?
Very insightful question.
Determined as of the petition date, so I don't think that would help you.
Never mind. That was a terrible question.
That is why I am a robo-silent.
I got a question.
Yes, sir, Mr. Lewis.
You two are great. I love you guys. But
Thank you.
I'd like to hear from anyone who's doing something like this in the middle or the western district, just to get a feel for what's going on. I got some cases up there.
Very good question. Mr. Lewis would like to know if anybody in the middle or western district are looking at these issues. I asked a year and a half ago. People looked at me like I was from another planet. Has that changed? Is anybody in the middle or western district dealing with these issues? Are there any pending cases? Does anybody know anything about this? Am I still from another planet? Is the East just different? There's the hand there with Kate.
We don't want leverage so far. We haven't actually filed the suit just to say, hey, we think we're going to do avoid this, let's study the deal.
Okay. You use it to work something out with creditor. Okay. Kate?
I know that Brett Saslow, a trustee in the Middle District, looks at these issues. I was involved in how we settled with him.
Okay.
Where it came properly notarized. I'd like to be properly notarized.
Right. So it was a notary issue and Saslow resolved it with the bank.
I know, so he's looking at those issues. Never had in the past.
And I think, yes, sir.
Bill Miller got a
You have a missing notary in a case in the Middle District with Bill Miller.
Husband and wife, only husband's signature.
You mean the notary has disappeared? She can't be found?
I'm sorry, the missing is back acknowledged.
Oh, bad acknowledgement, okay. And was that filed as adversary proceeding?
Yeah, we filed it 2 or 3 weeks ago.
Should have hired me.
And that may bring me back to the, you may find the, Angel versus Williams case instructive in that regard.
There is also in the Middle District, and I think it's on appeal, you said Northern versus
McCormick.
McCormick.
That's right.
The criminal attorney, but where, and that's just going to be an Orange County thing.
Right.
The PIN number is not legal description for that.
In the Northern versus McCormick or SunTrust case, that's the one where the Orange County property had the wrong PIN number.
But it sounds like it's in a way similar to the Rose case, because it's Orange County PIN number is not.
Right, exactly. So, depending on what happens with Rose, maybe the same result in that Northern case.
Mr. Butler,
Yes, Robbie.
if in my earlier question, which you poo-pooed, the deed of trust is void on the date that the petition is filed, would you not have a potential debt limit problem in the 13th?
You know, Robbie, that's an excellent point.
Very nice, Robbie. I think you have redeemed yourself.
I recovered.
Very nice, very nice. Now, I think what you'll find,
No answer?
no, you're not going to answer your question.
Well, I think Robbie's making the distinction between deeds of trust in which the underlying transfer was ineffective, like the property description. If there's a defective property description, the transfer is not effective. If there's a head grading solution, the underlying transfer is not even effective. There's no security. But if you have a defective acknowledgement, you say, there is a security interest there. It's simply unprotected.
Okay.
And would be a security interest.
I think what we found is that since we have a body of law here, it makes it easy to resolve cases. And so there are a lot of other issues that are cases that are not reported because they're resolved, they're settled. You mentioned that you're able to try to work things out sometimes with the bank because nobody wants to, to be the next. They don't want to be the 13th case. We just talked about in a couple of years. And I think that our judges have done a wonderful job of kind of defining what those limits are. And so as a trustee, you might say, well, I'm not going to bring that case because it's silly, it's a waste of time. Or as a bank, you might say, or title company, I'm not going to defend that because that's a waste of time and money. Let's just work something out and fix it. I was talking to Charles Zimmerman about that the other day, and I called him up and I said, here's a head grading kind of issue, and we talked on the phone for 30 minutes, and he convinced me that I was wrong and probably saved me a lot of time and effort, which was very nice. But because we have this body of law, it makes it easier, just like any legal issue that we come up with. Yes, sir, Mr. Angel.
Can a trustee agree with a creditor to reform the deed of trust over the objection of subordinate?
Can a trustee agree with a creditor to reform a deed of trust over the objection of subordinate lien creditors? Al, I think he's asking you this question. I could answer it, but
I don't know the answer to that. That's an interesting
He
question.
avoided 551 from service.
right, for the benefit of the state.
Junior mortgage means from slipping forward, so you could argue that a settlement with them, he stands to that in that situation.
I think it would be a fact-specific analysis in which if you have a slam dunk question of the avoidance of the deed of trust, and it was void, then I think the intervening creditor would be successful in that objection. But if there is an arguable basis, and you're in one of these gray areas where you can't kind of figure out whether you're in law developers or head, and really unsure how the court's going to come out. It seems to me the intervening creditor would be a party to at least that settlement.
And that's what is good though, man. It sort of depends on whether you're